I'm going ahead. I want to request a new lawyer. He's not a representative.
Here's the thing. You don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not, just because
Can I speak?
Nope, not while I'm talking. I already gave you an opportunity earlier, and I'm going to give you an opportunity in a minute, but I want you to listen carefully to what I have to say first, okay? Good morning. Are you Justice Larzzo?
Yes, ma'am.
And Mr. Larzzo, in cause number 26, DCCR 0770, you're charged with a third-degree felony offense of obstruction or retaliation from March 8th of 2026. Your indictment alleges that you were previously convicted of assault on a peace officer and assault on a public servant on October 12th of 2023, both of those cases on the same day, which means if you go to trial and are found guilty in these cases, or this case, and those prior offenses are true, that means you would be considered a second-degree felony for punishment, which is between 2 years up to 20 years in prison. Do you understand all of that?
You can repeat that for me?
What part of it do you not understand?
The first part.
What you're charged with?
The one way you said.
So here's the thing. You're charged with obstruction or retaliation.
Correct.
The offense date is March 8th of 2026.
Correct.
And that's a third-degree felony.
Correct.
The indictment also shows me that you were already convicted of 2 other felonies on the same day. What that means is if those are true, or at least one of them is true, it would enhance your punishment in this case to a second-degree felony, which means if you go to trial, you're found guilty, the range of punishment is between 2 years and up to 20 years instead of 2 to 10. What?
I would like to take care of this today.
Well, talk to your attorney and listen to what he has to say. And if y'all want to take care of it today, then there's some paperwork that you have to go over with and sign, and then we'll go forward. All right? You can go back with the bailiff. All right, Mr. Larzzo, what's going on?
I'm going ahead. I want to request a new lawyer. He's not a representative.
Here's the thing. You don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not... Just because
Can I speak?
Nope, not while I'm talking. I already gave you an opportunity earlier, and I'm going to give you an opportunity in a minute, but I want you to listen carefully to what I have to say first, okay? Mr. Rojas is telling you what the district attorney's office is offering. You don't have to like it. It doesn't mean he's a bad attorney, and another attorney is not going to come get a different offer.
Okay.
So, Ms. Malfino, is there any reason that you would know of that offer that you have made would change?
No, it will only go up.
So you're where you are. So either you accept that offer or we set your case for trial. Once your case is set for, hang on.
I want a new lawyer.
Hold on. I understand, but listen.
Let me speak, man. Please, can I speak?
I'm going to let you speak, but I'm going to give you what your options are, okay?
All I want is what I'm saying. You trying to say trial, this and that. I haven't even seen my discovery evidence. You saying he's a good lawyer, but he haven't even shown me no evidence. So on my case, how can you speak and say he already told me the other day that he working for the DA? He already said. Sure I said you haven't. He have not asked me what happened. He haven't even got my side of the story. Have you got my side of the story? Have I told you what happened in this case? Can you tell this person what I told you?
Mr. Larzzo, you're not in charge and you're not asking a question.
I'm not in charge, but what I'm saying is, how can he say he can represent me and he's ain't done nothing but come to me and say the DA said this, the police report said this. He has not.
That's the evidence. That's what he's telling you. The evidence is what's in.
What the police report said, but he hasn't asked me my side.
And here's the thing, your side is important if if you didn't do it. What his job is to tell you this is the evidence they have against you. You can take this deal, or if you say you didn't do it, you can go to trial. So if you're saying you didn't do it, then let's get a jury to determine if you did it or not.
I haven't seen no police report. I haven't seen no body cam footage. I haven't seen no evidence to where I can tell you if I'm ready to go to trial.
Is there media in this
Judge,
case?
As Mr. Rojas does in every case, he has requested and reviewed the discovery well in advance.
Do you want, let's do this. Do you have some media?
Judge, I have requested the media. What I told Mr. Larzzo yesterday when he told me he wanted to watch the video, I told him we could reset the date to look at the video. He just said he didn't want to do that. He just wanted to come in and ask for a new lawyer.
I want to know because you now represent me effectively. You come to me and tell me the DA said this.
Mr. Larzzo, he's just said that yesterday he would bring the videos. Don't talk over me. He would bring the video for you to watch. I'm going to reset your case for 2 weeks. He's going to bring the information. You can watch it and you can make your decision. The offer is what the offer is. The DA's already said that. I don't care if you take it or if you don't take it. Take it, fine. Don't take it. We'll get your case set for trial. You need to be respectful. Mr. Rojas is going to get out there, show you everything. You don't get to keep copies of things by law. He doesn't get to hand you a police report and you keep it. That's part of the law. So he can go over that with you, read what it says to you, show you the video, and then you can make your decision. Go back with the bailiff.
May I ask a question?
Nope, I'm done today. Go back with the bailiff.
I'm not understanding how you can give somebody 4 years for an aggravated charge.
Let's go.
And try to offer me 5 years for non-aggravated. Let's go.
All right, ma'am, are you Kashonda Riley?
I know it's a big ask, Judge, and it's not something that the court, I think, probably is leaning toward, but we're asking the court to consider probation in all these cases. Ms. Riley is 27 years old. She's got 2 young kids at home. As you can see from the PSI, most of her previous offenses are theft or some type of deception cases. And certainly she's old enough to know better. She should know better. I think if you look closer at her background, it's a situation where she never really had a chance to get any kind of direction in her life. She was placed into CPS custody when she was 3 months old. I think she lived with her aunt until she was 14. I think all that time, or most of that time, her mother was in prison. And when her mother got out of prison, Ms. Riley went back to live with her mom. From 14 to 17. At 17, she ran away from home. And I think her father's in prison now. I don't know how long he's been in prison, but he's in prison now. I think the easy thing to do is to go ahead and send her to the state jail. Not only for the court, the easy thing for Ms. Riley would be to send her to the state jail so that when she gets out, her slate is clean. She starts all over. I don't know that that's going to... I think if that happens, Judge, she's probably going to be back in the same place she's at, committing offenses, committing more thefts. What I'm asking the court to do is consider probation with possibly ISF, the cognitive track of ISF, so that she can get some direction, hopefully start learning how to make better decisions, and get her life onto the right track.
You were on probation. You've had 1, 2, 3, 4, 5, 6, 7 probations. 7. You were given a probation for this felony, and 4 months later, you picked up 2 new theft cases. You've had every opportunity for whatever help it is that is out there. It's not like you've just taken time and not had opportunities with probation to help you. And so at this time in cause number 24, DC, excuse me, 24, DCCR 1778, I'm going to find that you entered your plea to true, freely, and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 26, DCCR 0210. Find that you pled guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 26, DCCR 0211, find sufficient evidence to find you guilty of theft of property. Find you guilty of that offense, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of those cases that shows that these were agreements that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. There's a real easy way for you to stop being incarcerated, and that's to stop stealing. You can't expect to keep doing the same thing and not have more harsh consequences. And so you need to understand that when you get out of state jail, if you do this again, it's going to get worse every single time. So if you want to be there for your kids and break the cycle, then that's going to be up to you to break that cycle. All right. So Mr. Mink, in cause number 23, DCCR 1851, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the third-degree felony offense of evading arrest or detention with the use of a vehicle. And that was a 4-year deferred probation. Is that correct? And in cause number 24, DCCR 0294, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for aggravated assault with a deadly weapon, a second-degree felony, and that was a 6-year deferred probation. Is that correct?
Yes.
Okay. All right. I'm going to find in each of your cases that you entered your pleas of pleas are true to counts 1 in the one case and then 1, 2, and 3 in the other, freely and voluntarily. Find all of those counts true. In cause number 23, DCCR 1851, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a motor vehicle. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 0294, find counts 1, 2, and 3 true. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case. The two cases, or the two sentences, will run concurrently, which means together at the same time. Shows that you were placed on probation January 25th of 2023 for the third-degree felony offense of obstruction or retaliation, and that was a 3-year deferred probation. Is that correct? The motion alleges that you violated your probation. Is that 1 through 5?
It is, Your Honor.
Count 1 alleges that you provided a urine sample June 26th, October 15th, and November 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
Yes, ma'am. True.
That's marijuana.
Yes, ma'am. True.
Okay. Count 2 alleges that you failed to successfully complete the GED program as directed. Is that true or not true?
True.
Count 3 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you tested positive for alcohol June 26th and October 15th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening October 14th of 2025. And is that true or not true?
True.
And then count 5 alleges that you failed to successfully complete the moral recognition therapy program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue your probation and extend it for 2 years. Order that you enter and successfully complete the JCDI program, which would also include a drug patch. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted any evidence that Ms. Verdine is not competent.
Oh, yeah.
So I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I do want to get an updated report. So we need to figure out between now and then what I can do between now and then. I just want to make sure that probation also agrees that that's all of the treatment and everything that's necessary. I'm willing to set a bond, and she's on probation. She can go ahead and start those programs, but I want to make sure, I think that we're covering everything, if that makes sense.
Judge, she's been incarcerated for a while. Would the court consider PR bond?
Yeah. So, okay. So what I'm going to do, Ms. Verdine, is I'm going to reset your case for sentencing. I'm not going to sentence you and extend it today. We're going to do that later. But I am going to reduce or set a bond for you in the amount of $1,000, but make that a personal bond, which means you don't have to pay any money. You're just going to get out of jail.
Yes, ma'am.
You're still on this probation. You're required to do everything, including starting that JCDI program. You have to have a drug patch on within 24 hours of your release from custody.
Yes, ma'am.
If you don't do that, I don't have to go along with this agreement when you come back. If you test positive between now and then, you're going to be right back in jail. Do you understand?
Yes, ma'am.
You can talk to your probation officer about where to get that drug patch. They'll help you with that, and then we'll see you back at sentencing, okay?
Yes,
All
ma'am.
right, you can go back with the bailiff.
I have a question.
Hang on just a second.
Is the drug patch right now just going to be a condition of a bond, or?
It's going to be both.
Okay.
It needs to be a condition of probation and bond. Yes, ma'am.
I forgot what I was saying.
Sorry.
So I forgot.